I don't know if I can yet, but I'm planning for it.
Hello, everyone.
Hello.
Hello, and welcome to 2022 Constitution Day, a part of being able to participate in the U.S. Department of Education and being able to give student loans. We are given the opportunity in order to share across the nation about the Constitution. Today, we have Reverend Ron Buck, who is the senior minister of Collierville Christian Church. And he's going to share about something that he's been working on for a while now, and it is the American Church and the U.S. Constitution. So I'm not going to delay any further, but I'm giving him the space in order to share what he's been working on and also give us room to be able to ask questions. We are doing this hybrid. Thank you, Dr. Detke. We are online, so we have a video that is streaming in. And so for those of you that are online, please place your comments and your questions in the chat. And when Q&A comes, we'll be able to offer those questions to Reverend Buck. Will you all please give him a hand?
Yeah, such a nice way with words. What she actually meant is you kind of have to do this. You don't have to listen, but the seminary kind of has to provide this. It's one of those strange interactions between the church and the state that we're going to talk about, because the state has a way of making requirements on churches and church-related institutions that sometimes will get questioned based on the First Amendment. So we're going to talk about that. But I want to start with this. In June of this year, and some of you will remember this, Rusty Bowers, who is the Speaker of the Arizona House of Representatives, was testifying before the House Select Committee to investigate January 6th. And he said with great emotion, "I believe that the Constitution is divinely inspired." Then he went on to say, not only did he believe that, but that was one of his most deeply held beliefs, that the Constitution, U.S. Constitution, is divinely inspired. A lot of people heard that and had questions. I was one of them. I had calls from friends who know that I teach American history and that I'm a minister, asking, what do you know about the belief in the church that the Constitution itself is divinely inspired? And the truth is, I didn't know very much. And I did know that Mr. Bowers is a member of the Church of Jesus Christ of Latter-day Saints, but I didn't know much about their teaching regarding the Constitution. So I researched it, and you can't see my notes, so I'll tell you, research is in quotation marks. I actually Googled it, is what I did. I Googled it, and I found out that Mr. Bowers is correct, that it is a relatively widespread core belief within the Church of Jesus Christ of Latter-day Saints that the Constitution is a document that is divinely inspired. And it is not just a sort of recent development. I would have guessed maybe 1890, when Utah became a state, that was something that the church decided together. But it actually goes back to Joseph Smith, apparently, because it's in Doctrine and Covenants. And some of the earliest writings in the Doctrine and Covenants, this is God speaking through a prophet. "For this purpose, I have established the Constitution of this land by the hands of wise men that I raised up for this purpose." So it's a belief within what we think of usually as the Mormon Church that the Constitution is divinely inspired. And I assume in a similar way, Scripture is divinely inspired. About a year before Mr. Bowers, so back in 21, the first counselor in the first presidency of the Church of Jesus Christ of Latter-day Saints, a man named Dallin Oak, published an article in Deseret magazine entitled "Our Inspired Constitution." So this is well before Rusty Bowers. And in that, he maintains that the Constitution, these are his words, "The Constitution is divinely inspired because it contains principles and rights that bless not only this nation, but also the world." And that's the strongest case that he makes for divine inspiration. It doesn't sound like a case to me. The fact that it's beneficial to a lot of people doesn't necessarily make it divinely inspired. But he goes on to suggest that, and it is true, at one point, George Washington referred to the Constitution as a miracle. Again, not quite divinely inspired, but that is his position. Dallin Oaks. And Oaks is not just a high-level LDS leader. He's an attorney. He's a law professor. He's a jurist. He served on the Utah Supreme Court. And there is reason to believe that he was considered at least once, if not twice, as a potential nominee for the U.S. Supreme Court. And his belief is that the Constitution is divinely inspired. Now, I'm not trying to argue for or against that belief, but the fact that about 2% of the U.S. population is Mormon, and Mormons are politically active, that means this doctrine is statistically important. If 2% of the people in the country believe that, that's worth noting. And those are people who vote and run for office. But then guess what I found? And not on Google, real research. I found that in a Pew Center research survey from early 2021, 18% of Americans surveyed believe that the Constitution is inspired by God. 18%. That's almost 1 out of 5. If you reduce that to evangelical Christians, it's 37%. Well over a third of evangelical Christians believe that God directly inspired the U.S. Constitution. Another thing I found from that same survey is that about 1 in 5, just under 20%, 19 point something percent of Americans, religious or not, 19+% believe that the federal government should stop enforcing the separation of church and state. Just quit doing it. Let people do what they want. Now, I do want to say this topic was a stretch for me. This is not ground that I covered in graduate school, in church history, or American history. I didn't really study the Bill of Rights. I've done more reading and research on the Constitution, the federal government, and the church in the last 6 weeks than I did in all my years teaching undergraduate college history, where I only talked about things like Marbury versus Madison and judicial review, that sort of thing. I do want to say that if this interests you at all, of all the things that I've read this summer, this book by Ronald Flowers, he's now deceased. It's about 15 years old. That Godless Court with a question mark. It's probably the most informative thing that I found. So if you want to know a little bit about more court cases than I'm going to mention, this is an excellent book. There is also at Middle Tennessee State University, online, accessible online, a website devoted to church and state and interpretation of the Constitution in regard to religious institutions. It's got far more than that. But any case you want to read, you can read the briefs, you can read the decisions, you can read the dissents. It's a very, very comprehensive website. That's MTSU. I don't think I have the web address for that, but you could Google Constitution MTSU and you would find it. So what I'm going to talk about mostly in the next few minutes, and then we'll go wherever you want to with questions. We have an attorney, so you got a church guy and an attorney. He's probably a church guy too, but so maybe the legal technicalities we could even explore a little bit. But mostly what I'm going to talk about is the First Amendment. I'll end with a little bit on the 14th Amendment, but primarily through American history, the cases have revolved around the First Amendment, Free Exercise Clause, and Non-Establishment Clause. We'll unpack those a little bit. We talk about separation of church and state. First Amendment does not say that. It says that the government cannot establish a religion or prohibit the free exercise thereof. Thomas Jefferson is the one who said wall of separation. And he said it in a letter to the Danbury Baptist Association from Connecticut in 1802. He was a relatively new president. The Danbury Baptist Association felt it was being oppressed by the official, semi-official Church of Connecticut, the Congregational Church, that they were being persecuted and oppressed because there was a lot of government support for the established church and they were discriminated against. And so Marbury versus Madison wouldn't have even been written yet, that decision. So Supreme Court wasn't the place to go. They went right to the top. They wrote a letter to Thomas Jefferson, and he wrote them back and said that there must be an eternal wall of separation between the church and the state. And he went on to say that not only should there be that separation, that wall between the church and the state, that as president, he felt it was his duty to be very private and reserved about his own religious practices and beliefs, because he didn't want people to think he was setting an example for what other citizens should believe. So there was this robust understanding in the mind of Thomas Jefferson of this wall. Now, the Baptist I've already mentioned, I make a note of that because a little later on, we're going to find out that most of the opposition to too close a connection between church and state, most of it's going to come from the secular world. And even one case I'm going to mention is Madeline Murray O'Hare. But the first question about why aren't you separating the church and state more distinctly comes from a religious group. And I think we need to remember that. In the early years of this republic and the Constitution, it was usually religious people who were concerned about establishment of church and state, not some secular enemy out there trying to keep the church from doing what it needs to do. And that's important. The roots of the separation between church and state go back before the Constitution. I don't want to tell you, I've got a lot in this original paper that I did that I'm going to skip over. We could talk about it more in the questions if you'd like to. But Dr. Flowers, who was also a disciples minister as well as a historian of religion, he really finds the roots of separation in the colonies and in the Great Awakening, First Great Awakening. People were experiencing faith in settings outside the church. And one of the arguments in Europe for an established church, well, really two major arguments for keeping an established church. One, it creates a stable social order. If you've got everybody believing about the same thing and going to the same church and following the same practices, you have a lot of influence over how they live and what they do. So stability was one reason. And the other reason in Europe is they just really didn't think people would stay connected to the church unless it was kind of enforced. And what the Great Awakening in England, but especially in the colonies, demonstrated was that people can have an even more vibrant faith if it's by choice rather than establishment. And so disestablishment, and that's a term you run across quite a bit when you're reading about the Church of England, all during the 17th and 18th century, people pushing, usually religious minorities, pushing to disestablish the Church of England. So it really goes back beyond the First Amendment. There have been historically really two camps of interpretation on what the First Amendment means, the Establishment Clause in particular. The first was Jefferson's, the separationist approach, that the less interaction you have between the government, at first the federal government, later the state governments, the less interaction, the better for both. The government, let the government do what it needs to do without the limits and constraints of the church, and let the church do what it needs to do without the support or constraint of the government. And that really held for about a century and a half. That was the primary understanding of the Establishment Clause until the middle of the 20th century. Mostly during the 19th century, when religious issues would come up, they were about the free exercise clause. And we're going to talk about it too. But no one really challenged the idea that the church should be separate from the state through the 1800s until sometime around the late 1940s, 1950s. We're going to mention a couple of cases. One of the first cases that I want to mention was in late 1870s. It was I'm not going to tell you all about it, but it was Reynolds versus the government. George Reynolds was in the Utah Territory. It was not yet a state, wasn't a state until 1890. So it was a territory still. And he violated an 1862 bigamy law. And it ended up in the Supreme Court. And it's amazing. I read the whole case. I didn't just read a summary of the decision. The court took this really seriously. He broke a law, but he says the law should not be binding because it prohibits his free exercise of religion. Not only did they consider that question, they considered the question as to whether it was right for the federal government to be able to pass a law that was incumbent on territories that were not states. I mean, they looked at every aspect. And here's what they finally decided. They decided that separation of church and state is necessary for the good of the government, and free exercise is necessary unless it violates moral, social, or health standards. And they believed that in the case of bigamy, there was a prevailing interest on the part of the government not to allow plural marriage. And so they found against Reynolds, but they upheld separation of church and state. One of the first cases that shows a little bit of a shift in the understanding of separation is 1947, Everson v. Board of Education. The case involved a decision by the state of New Jersey to allow local school boards to reimburse parents of parochial school students for bus transportation to and from school, because the state funded public transportation for students. And so the state of New Jersey decided, well, we need to reimburse parents of private schools for the cost. Justice Hugo Black wrote the majority opinion, and he cited the Danbury letter and Jefferson's wall of separation. He said the wall must remain high and impregnable. However, he and 4 other justices held that reimbursement for transportation did not qualify as an establishment of religion, and so they let it stand. They allowed New Jersey to reimburse those parents. They said that free exercise could not be infringed. So separation is important. Funding bus transportation doesn't go beyond that, and free exercise then trumps the question, and you can pay for their transportation to school. The very next year, Mccollum versus Board of Education, 1948, shows that despite the outcome in Everson, the court was still decidedly separationist. I won't go into all the details about Mccollum. We don't have time. But it was over whether a public school could provide private religious education during the school day if it was voluntary. So can we have religion classes as long as the parents sign off on them? This was an 8-1 decision that having religious classes, even if they're voluntary, violates the Establishment Clause. The federal government and the state government together would be funding a public school that would be providing religious education, and not all of the students would be from the same religious background. And so they decided that they could not allow that. 8-1. The lone dissenter was Stanley Reed, Justice Stanley Reed, who was, I'm not playing partisan politics here, Hugo Black, of course, was an FDR appointee, a Democratic appointee, and he was writing all the decisions upholding church and state. Stanley Reed is going to be one of the first ones, a Republican appointee, who really lobbies for more and more toleration of the exercise of religion on public school grounds and during public school schedules. 15 years after Everson v. Board, there was another First Amendment case. This one's going to surprise you. And this was in the early 1960s, 62 or 63. The New York State Board of Regents wrote a prayer. The State Board of Regents, who oversaw education, wrote a generic prayer. A lot of people, religious people, referred to it as the "to whom it may concern" prayer, because it really was not specific at all. And by the way, that's one of the problems of trying to include religion in a public education curriculum or a public state house or whatever. You're not going to please very many people unless you get very specific, and then you discriminate against a lot of people. It's one of the reasons that churches and synagogues and mosques ought to be teaching religion, and public schools ought to be teaching math, science, history, and the like. But Justice Black wrote the majority opinion on this particular case. New Hyde Park was one of the school districts that immediately instituted this prayer, along with Bible reading at the beginning of every day. Several parents filed suit separately. The suits were kind of combined. It went to the Supreme Court in 1962. Two justices did not take part at all in the discussion or the decision, so there were only 7, and it was a 6-1 decision, with Stanley Reed once again being the lone dissenter, and Hugo Black wrote the majority decision. One more I'm going to mention in that vein, just because it's an important case. It was the next year. It was in 63. It was really 2 cases. One of them was in Pennsylvania against prayer in school and Bible reading in school. And it was filed by the Shimps. They were a Unitarian couple, so they were religious. Evangelicals might say not very religious, but they were Unitarians. They were religious, but they did not believe it was appropriate for the school to start each day with prayer and Bible reading. And so they brought suit. Madeline Murray O'Hare, who was an atheist, also brought a suit because she didn't want her child subjected to the prayer. And they named it after Shimp, but O'Hare is the one that everybody remembers. And the school district argued that the readings and the prayers had a secular purpose, that they'd made it a generic prayer, so it shouldn't offend anybody, and the Bible readings were to teach literature. The court didn't buy their arguments. They found that the prayers and the readings were unconstitutional. Tom Clark wrote the majority opinion in this one, and Potter Stewart, another Republican appointee, was the lone dissenter. All through the 60s and 70s, the rule of thumb was still separation, but you can see the beginning of the dissent. The dissents get stronger and they get more numerous. Instead of a lone dissenter, by the 70s, the moral majority, all that was going on in the country, you'd have 2 or 3 dissenters, very vociferously dissenting from the majority opinion. In the 1970s, 2 states at least, Pennsylvania and Rhode Island, were both using tax dollars to reimburse religious schools for teacher salaries, textbooks, and other materials. What most people saw as a blatant violation of the Establishment Clause. A number of cases were filed. In a lot of these school cases, there'd be many cases, and they consolidate them instead of hearing a dozen. And it was known as Lemon versus Kurtzman. The court used that opportunity to try to determine what exactly violates the Establishment Clause. And this is what they decided. And they still used it up until recently. And they probably still talk about it. but they seem to have kind of cast it aside. They called it the lemon test. And it said, the first question to ask is, does the statute in question have a secular purpose? There has to be a non-religious purpose for whatever you're doing. That's it, called into question. Secondly, does its primary effect advance or inhibit religion? And if it does either, it fails. And the third is a little more ambiguous. The statute must avoid excessive entanglement with religion. And of course, what exactly constitutes excessive entanglement would be left up to the person deciding. And now, by the 80s, we have Justice Sandra Day O'Connor. And she and a few others like Potter Stewart were far more comfortable with the government providing resources to school and allowing religious exercises in school. And it's interesting, in 1985, there was a case, I won't go into it other than to say that the city of New York was paying remedial teachers to go into religious schools and try to catch students up on math and reading and some of the basics. They were falling behind. They were in private schools, but the government decided it was in the public interest to pay teachers to go in and try to help those, mostly low income, at-risk students. And the Supreme Court felt that that was a violation, that religious schools that want to be private have to hire their own teachers. And if they're not making it, that's their fault, not the public education, Board of Education or whatever, to go in and take up their slack. Sandra Day O'Connor was furious. She wrote a very scathing dissent. In fact, she didn't write the official dissent, but the official dissent was not scathing enough for her, so she wrote her own dissent. And about 10 years later, a very similar case came before the Supreme Court, and she got to write the majority position, opinion, 5-4, that it was okay for remedial education to be provided to parochial or other religious schools. See, that's the point I'm trying to make with all of these. There is a shift from the 1870s, really, 1920s, 1930s, 1940s, that the Supreme Court would occasionally allow some interaction, but they were very skeptical of it, and they insisted. In fact, Hugo Black said in one of his decisions that I don't care how religious the people in the country are, we have to maintain the law of separation. They can be as religious as they want to, but the government can't be. That was definitely not the case by the 1980s. And as we got a more conservative Supreme Court that was far more friendly to involvement, entanglement of the government with the school, you get more permissiveness. And that is the accommodationist approach. And that's where we are today and have been really since the 80s or 90s, but a lot more accommodationist over the last decade or so. That if the government can assist a religious institution without clearly discriminating against some other group, then they're allowed to do it. So it really puts kind of the burden on those who would argue against it. They have to prove that it does discriminate in some way. And earlier, the burden had been on the side of the religious institution. You've got to prove that there is an absolute need for this and it doesn't violate it. And kind of the shoe is on the other foot now. We could also talk about, and I want to do this in closing so there's time for questions. I know people are wondering about more recent cases like Dobbs V Jackson, which overturned Roe v. Wade. There can be no doubt that religion played the largest part in overturning Roe v. Wade. The groups that mobilized for the last almost 50 years, 73, almost 50 years, to oppose Roe v. Wade have mostly been religious groups motivated by religious interests and beliefs. But it's not a First Amendment case. Dobbs v. Jackson or Roe v. Wade. Roe v. Wade was the 1973 case that said women have a right to seek an abortion. Dobbs v. Jackson is the recent case this year that said they do not have that right. Neither one of them are based on establishment of religion or free exercise. Those cases were based on the 14th Amendment, equal protection under the law. And to a lesser degree, the 9th Amendment, which is the next to last amendment in the Bill of Rights, which essentially says, it's a lot more verbose than this, but essentially says there are other individual rights that are not enumerated in this document. It's kind of giving Congress the right to pass laws that will establish new rights, and that those rights are protected as well. Now, I know this is a religious institution, and I'm an ordained clergy, and there are differences of opinion. I support Roe v. Wade, and I really don't see this as a religious question in terms of the particular cases. It doesn't hinge on separation of church and state. It hinges on equal protection under the law, which could be religious or non-religious or secular or whatever you want to call it. There is a lot of religious fervor right now with a conservative court related to Obergefell v. Hodges that allowed same-gender marriage. But again, the First Amendment doesn't have anything to do with it. This is not a church and state argument, but it certainly is a religious argument. The opposition to same-sex marriage, the basis for the decision guaranteeing that right, Obergefell v. Hodges, is also based on the 14th Amendment, equal protection under the law and due process. If Obergefell v. Hodges is overturned by the current Supreme Court, I think it'll be a travesty of justice. I don't think it's out of the question that they will overturn it. It won't have anything to do with the First Amendment, but it will be based on the 14th Amendment. Now, a little more speculation. A lot of people have called into question, will Loving v. Virginia be overturned? And people like, oh, no, we'll never do that. That's established law. That's been forever. I was born before Loving v. Virginia. It was late 60s. Legal scholars have some concerns because that decision is based on the same 14th Amendment that Obergefell v. Hodges and that Roe v. Wade. And if a court can overturn a due process, equal access argument, they can overturn Loving v. Virginia, which made illegal across the country interracial marriage. It could be challenged because the basis for all those decisions, the basis is the same, the 14th Amendment, due process, equal protection. I am far less likely in 2021 and 2022 to say that'll never happen. Because I used to say that as an undergraduate history professor. We talk about the future, and I believe Nathan Hatch and democratization, and our country's not perfect, never has been, never will be, but there seemed to be a trajectory toward more and more people at the table, more and more acceptance, more and more participation. And I believe I have learned a hard lesson in the last 4 or 5 years that the forces that were placed at bay in order to make that happen did not go away and did not lose the battle. They weren't winning, and so they were quiet and worked in another another venue until they could come out ahead. I'm really not sure what kind of religious challenges we're going to see to the First Amendment. The 14th Amendment, I think, will be more a question. And I really, again, I used to say that'll never happen. I'm not going to say that now. I have no idea what will happen. So I'm going to stop there so we have a little bit of time for comments and questions. I know I must have left out a lot of cases that are important. I'm not a lawyer, never trained in the law. I read those documents as a historian rather than a lawyer.
Do you think that the fact that Clarence Thomas is in an interracial marriage will have an effect on whether or not that case is overturned?
You would hope so, but I don't say yes. I say you would hope so because it's been my experience here in Tennessee. We have plenty of people in the state legislature that want to ban abortion in Tennessee until it's their mistress that's pregnant, and then in private. And I don't know if Clarence Thomas would be that duplicitous or not, but his would be grandfathered in, maybe. I really don't know. But it's a good point, and it should make the argument that at least as long as he's sitting on the bench, they're not gonna pass. They're not gonna overturn Loving v. Virginia.
So I'm curious what you think as a historian has driven the change from kind of the stricter wall of separation sort of approach to this more accommodationist approach. What's going on socially, politically, economically, culturally that could be driving that?
This is my cynical view. I think that particularly during the 19th century, but the first half of the 20th century, that most church folks, and I'm not just talking about clergy and leaders and maybe activists, but most people that fill the pews were perfectly content practicing their religion at their church or synagogue or house of faith, wherever that was, and really didn't spend a lot of time worrying about whether the government is going to fund it or whether we ought to be able to espouse our religion in a public setting where we can reach other people. They just kind of went along on their own tracks. I think that certainly in the middle of the 20th century, there was a realization, and I don't know who to attribute it to that far back. I do know that by the late 60s, we can say it's part of the Southern strategy. But even as early as the 1940s, there was a conscious effort on the part of conservative Americans to get as many people on benches, federal benches, as they possibly could. I think as long as you had relatively secular people on the federal court benches and on the Supreme Court, the state Supreme Courts, there was less interest in trying to push these boundaries because they weren't guaranteed to win. I also think that anytime anything is allowed, if you move the boundary just a little bit, there's going to be another effort to move the boundary a little bit further. And I think people who want to see more of the government's support of religious institutions, people like Stanley Reed, and then Potter Stewart, and then Sandra Day O'Connor. There were plenty of political strategists reading those decisions, whether we were or not. And they realized that they did have a voice in the court. They didn't have a majority and say 85, but they had reason to keep pushing the cases, get cases in the pipeline, and get judges in the pipeline. And by the 1990s, they saw that there were cases they could win on a narrow margin. Most of them. Now we're not going to have narrow margins. So I don't think there will be many more. I think Kennedy, Bremerton, the coach, who had prayer, so-called voluntary prayer on the 50-yard line after the game. And I say so-called voluntary prayer. I don't know how many of you have been a teenager. I guess all. How many of you raised a teenager? Certainly some. There is no voluntary practice in school of any kind. There is peer pressure. Not personal case. I had my daughter, when she was in middle school, she teaches now, but when she was in middle school, 12 or 13 years old, informed me that she needed to get to school in time for prayer at the flagpole. And I knew that was not her cup of tea. And I pressed her on it. I said, sure, if you want to go, you can go. And she finally confessed to me, well, they've been doing it for a couple of weeks now. Go. And all the girls on the volleyball team, that all of her friends were questioning whether or not she was really saved because she wouldn't go to prayer. And so she gave in to peer pressure. And she'd come home fuming about the kinds of things they prayed about. Because that's not the way we use prayer in our church or our family. But she had to be there because of the pressure. So I don't think we're going to see many of those cases, though. I think very few cases are going to make it that far because they're going to be 6-3, probably. Yes, public school. I've just always been a proponent of praying at church or mosque or synagogue or house church, wherever you worship, and doing public education things that can kind of apply to everybody at the public school. I don't think it hurts religion at all to say this is not the place that we. In fact, I was in a public school board meeting during those same years. They wanted to have a class at the middle school and have different local ministers, and by different, they were all from the same denomination, but they served different churches. Come in and do a prayer during homeroom at the beginning of each day. And I opposed it. I said, my church is less than a block down the street. Come and do it there before school starts. We'll give you a free room. I'll have coffee made. Then you're praying at a church, which is not going to bother anybody. And then they can go up to school. But clearly what they wanted to do, they wanted to catch the kids who weren't in churches, who wouldn't come to my church and pray and then walk up the street. And so I said, okay, listen, if you guys are going to do this, I want to be a part of it. We have in our community, we have people who are Islamic, people who are Hindu, people who are Buddhist, people who belong to the Latter-day Saints, people who are Roman Catholic, people who are Greek Orthodox. We need to line them all up and give every clergy person or church leader a chance to come in. So if they are going to, because that was one of their arguments, they can learn something about religion, whether they're evangelized or not. So let's really learn about what religion is like. Let's make this a learning opportunity and let all the communities of faith. And one person stood up and said, no, we just want something that won't offend anybody. And I said, you want something that's Southern Baptist or non-denominational. You want somebody to get up and say an off-the-cuff prayer without planning it out. You don't want any repetition or response. You don't want anything outside your tradition. And you say it won't offend anybody, but it will. It just won't offend people like you. They decided not to do it, not for the right reason. They decided to do it because they didn't want the cost of the court case. And if fear is the only way to keep somebody from doing the wrong thing, I guess I'm in that camp, at least when it comes to the First Amendment. But I think they know now they're going to win those. And so
Part of the reason I'm asking that question is I'm wondering about the shift in religious identification in U.S. culture that starting in the late 60s and accelerating up to the present, there's growing, big number that's growing are the nuns, the folks who don't belong to any religious tradition. And so you don't really have to protect the church using state power if everybody's kind of going to church. But now that the church is kind of in decline, now we'll try to use the state to enforce religious identity in some way. So I've got that in mind. But the other thing I'm kind of wondering about is, so in the current court, and I'm saying this as a Roman Catholic, so just anybody out there doesn't think this is like an anti-Catholic thing. 6 of the 9 justices are Roman Catholic. Yeah, and 5 of those are in what could be called kind of a conservative approach to Catholicism. The other one is probably more center or progressive. So it's fascinating to me that in a country that's been largely shaped by Protestant sensibilities around separation of church and state, you now have a Supreme Court that has a majority of Roman Catholics. And Roman Catholicism has had its struggles with separation of church and state. I mean, it wasn't even allowed sort of within Catholicism until the Second Vatican Council in the early 60s. So I'm asking, if I'm getting to a question, secularization, how might that be a force in this? And that sort of the counter force, you now have people who are in a religious tradition, at least 5 of those 6, who are thinking separation of church and state might not be a great way to go.
Well, the first part, I'm sure you're onto something. I think if people were crowding into evangelical churches today, there wouldn't be nearly the burning desire to walk into a public school room and lead a prayer and have a Bible reading. So I think even at that level, just numbers. If our building is packed every week and we've got all the people we can handle, but now we don't, and how are we gonna get those people? Well, public school is those students are there by mandate. And you may say the prayer can be voluntary, but how many of them are going to walk out of the room during the prayer, even if they're told they can, if they know their friends are going to question their faith or why, or you don't believe in God, whatever. So I think that's important. The second part, I don't think most of the evangelicals in this country are comfortable with the religion of the 5 or the 6, but they're not worried about their religion. They're worried about 2 things. One of them first, the second, Dobbs V Hodges. And they feel like Roman Catholic judges will be in the same camp that they are, and if your goal, and then to be fair, I think that there are a lot of people who oppose Roe v. Wade who believe that abortion is murder. And if you're trying to stop murder, I can understand using extreme measures. I can. I mean, hopefully some of us in this room, if somebody walked in with a gun and going to shoot everybody, we try to take them down. We might not normally be a hero, but if we think people are being killed, we might step up. So I try to be sympathetic. But I do believe that one of the reasons we have 6 Roman Catholic judges is because they're a pretty safe bet for the evangelical community that Roe v. Wade would be called into question. And, evangelicals can change their mind when they get into power, but Roman Catholics are a little more staunch in their beliefs. And that's very non-representative when you think 6 out of 9 judges belong to one, what Protestants would call a denomination. That's pretty stacked. And that's way above the statistical percentage of Roman Catholics in this country.
I had a list of questions to ask, and then just triggered another one, so I'll go with what just rose. Given the staunch holding of belief for presumptively Roman Catholic justices, how does one square that then with what appears to be misrepresenting what was true at their confirmation hearings?
You mean, why did they lie?
I'm
I'm just saying.
Oh, yep, plain language.
I'm pacing myself. I can get there. Just get
Okay,
going.
I'm just curious if I make sure I understand you right.
I believe its end justifies the means. We're trying to stop a travesty in this country. And by the way, I'm no fan of abortion. It's a medical procedure. I'm not in favor of any medical procedure unless it's needed or necessary. And I don't think I ought to get to decide that. And what I spoke to a more diverse group at a college in Kentucky. A lot of people kind of took me to task for being pro-choice. You know, if my granddaughter, who's a college junior, came to me and said, Papa, I'm expecting and the boy's not going to help. In fact, I don't really want him in the picture. I want to finish my nursing degree. I don't know if I can do that, having a baby. I think I need to terminate the pregnancy. My advice would be, you've got resources, son. I'll retire tomorrow and we'll take care of the baby and you go on with school. And I've raised grandkids before. I'm doing it now. But that'd be a conversation between her and me. And ultimately she would get to make the decision. I'm comfortable with advising her to have the child. What I'm not comfortable with is having the authority to tell you you can't have that discussion with or make that decision with your grandchild. You know, I can help make the decision for our family, but it's not right for me to get another family with completely different circumstances. You know, I'm not rich, but I've got the financial resources to take care of another child if I need to. It's not going to be a problem. But not everybody does. So that's where I stand on the pro-choice movement. It seems to me to be the only logical, reasonable decision. And the fact that the other side has to take a tiny percentage of the cases, late-term abortions, misrepresent them totally as an elective procedure, just a choice, in order to make their case. When you talk to somebody that's kind of in the middle on the pro-choice, pro-life question, and you accurately describe who's getting abortions and why, they're more likely to lean toward pro-choice. One other thing I did say at the college, and I should say here, is in the end, it's not the justice's job to decide what the majority of the U.S. citizens want. We didn't do that when it was a more liberal court. I quoted Hugo Black as saying, I don't care how religious the people are, the Constitution establishes this separation. And I think to be fair, you know, we're on the other side maybe if we're left of center. But I don't think it's incumbent on the justices currently on the court to decide what the majority wants. I think they've got the same task the earlier courts. What does the Constitution really guarantee? And I don't know that they're doing that either. I think that's what they ought to be doing. But just because, you know, I hear it every morning on NPR, I listen to NPR, every morning on NPR, 68% of the people in the country are pro-choice, 67% are for same-gender marriage. At the end of the day, that's not what the Supreme Court has to decide. I mean, if it were, all they'd have to do, and we've got the technology to do it, let's just take a mass poll around the country and see what they want to do this year.
Isn't that in essence what they did when they changed?
I don't know. I mean, I think the majority of the country, more than 50% are pro-choice just across the board.
Yeah, I think the argument is centered on the 14th Amendment. And I do think Roe v. Wade being overturned is arbitrary. Because from the time Roe v. Wade was decided, it was determined by a section of the legal community as legislation from the bench. And as a philosophy, which gave rise, even though it had happened previously with Loving and then later with Obergefell, you still have this sense that that is a power that a justice shouldn't have. That's for the legislative branch. And the philosophy under which this is a need that transcends the greater good, this is for the greater good, therefore this decision is one that at least those who were opposed to Roe v. Wade have been, to at least my study of it, have been organizing and biding their time for decades for a moment such as this.
And that's why I brought up the Ninth Amendment, and I didn't go into it much. The Ninth Amendment guarantees individual rights and liberties that are not enumerated in the Constitution. And I think our current, more conservative court, they're what in undergraduate history we call strict constructionists. what the Constitution says. And if it's not in there, it doesn't count. And I think they're basing these cases in large part on that right to terminate a pregnancy, that right to marry someone the same gender. That hasn't always been a right. It wasn't a right under the original reading of the Constitution. And so equal protection doesn't guarantee that. The 14th Amendment doesn't guarantee that. And they're kind of disregarding the 9th Amendment totally.
That's right.
They're kind of arguing if we haven't always done it that way, we can't do it that way now. And that the innovation to them was 1973. They don't see that as a fuller understanding of what equal protection guarantees. They see that as an aberration from what we'd accepted as common practice prior to 1973.
Sorry, what is the Ninth Amendment?
The 9th Amendment it's the next to last one in the first 10, the Bill of Rights. And it says, in the Bill of Rights, you've got the right to religious expression, freedom of speech, right to assemble, all these civil liberties, these personal rights. And in the 9th Amendment, I think they were genius in that they realized we're not going to be able to list all of the individual rights that people should have. Over time, there will be more rights. Congress will pass laws, culture will change. And so the 9th Amendment says there are rights that are guaranteed to individuals that are not listed here. And in Roe v. Wade in 1973, they did mention the 9th Amendment. Now they focused the case on the 14th Amendment, but they mentioned that the 9th Amendment allows for individual rights that are not a part of the Bill of Rights or the original Constitution before the first 10 amendments. And I think they're kind of downplaying the idea that you can have rights that are not listed. I mean, I don't remember what document they went back to, but the court, in writing the majority on Dobbs v. Jackson, cited something from the 17th century. I don't remember what it was. So these guys are old school. I mean, and I wondered at the time, and I don't even remember what the quote was, but how does that have bearing on the constitutional decision that you're trying to make if it was written long before the Constitution? Anyway, yeah, I think they're ignoring the fact that you can have rights that are not built in here. And I think termination of pregnancy was one of those rights. And I'm pretty sure, I'd have to look at my notes, I think the 9th Amendment was mentioned in Obergefell v. Hodges as well.
There's a lot of good constitutional arguments that you can make in favor of Roe. And I was in law school when Roe came, and we all sat down and read it and talked about it, tried to debated it in law school. It was fun, you know. But as I understood it, and I haven't read the decision for a long time, but it's based upon the right of privacy, which is not enumerated in the Constitution, but it's all around the Constitution. And there was, you know, the 14th Amendment did have the Adhesion Clause in it, which says that this is our Bill of Rights. They used to just were prohibitions against the federal government, but when the 14th Amendment was enacted, they were glued onto states too. That was, they called it the law of adhesion. So now states couldn't violate any of the Bill of Rights. So, and all of these rights, freedom of religion, freedom of press, freedom of not having troops stay at your house, were based upon an underlying idea of privacy. And so we have a right to be left alone. And I think that was, it's not listed. It's called they called it a penumbral right, one of Douglas's penumbral rights. It's all around there, but it's not specifically mentioned. But there are a lot of rights that we have that aren't specifically mentioned, as you pointed out. So I think there's good constitutional arguments to be made for it, but and just because something's not specifically mentioned in the Constitution doesn't mean it's not a right that we enjoy.
And I just think there's a profound difference between people, and I'm not saying one side's better than the other, then, well, maybe I am, but there's a profound difference between people who can say, these are my views and I believe these things strongly and I'm going to practice them and I'm going to make my decisions based on them. And somebody who says the same thing, and I want you to make your decisions based on what I think too. And that's the big difference for me. The story I often tell, you know, the United Methodist Church is going through an issue. I've got a good friend I've been talking with. We went through it in Disciples in 1993. My wife Kathy and I were a couple of the first people that I knew. In fact, I didn't know anybody who had joined GLAD in 1992. We did it after a really ugly scene in 91 at a nationwide, we call it the General Assembly. And just an ugly, ugly scene over accepting gay and lesbian members, considering ordination of gays and lesbians. Kathy and I decided to join GLAD, Gays, Lesbians, Affirming Disciples. And I told her at the time, I mean, I've got to stay at the church I'm at, or I've got to teach history, because I can't go back into our search and call process. I'm going to be flagged for this. In 93, that was 92, 93, we took our daughter for the first time to General Assembly because we wanted her, Desmond Tutu to speak, and we wanted her to hear Desmond Tutu, even though she was small and squirming in the seat. She has heard Desmond Tutu. And she got bored after Tutu, and there was some singing or something going on, and I took her to the display area, and somebody had put GLAD, which I belong to, their table, straight across the aisle from the Disciples Heritage Foundation, which was the conservative wing of our, and they were as close as Dr. Gatke and me, and they were just staring at each other. And so as we walked up, my daughter was 7, and we walked up and going to the GLAD table, one gentleman behind the GLAD table, minister in a suit, older guy, about my age now, looking at all the brochures and picking up brochures. And the polite person behind the counter said, if you'd like to donate $1, I'll give you one of our badges. And the little badge said, I'm straight but not narrow. The minister said, I don't want your damn badge. I'm not picking this stuff up because I'm interested in it. I'm taking this crap back to my congregation to show them what goes on at General Assembly. And I was just frozen in place thinking my 7-year-old is hearing this. She broke free from me, reached in her pocket, got $1 and said, I want a button. And that motivated me to move. And I got $1 and I got a button. Mine is still in my desk drawer. It's been in my desk drawer since 1993. And when I tell that story, I told it to my minister friend that I was on the phone with yesterday from the United Methodist Church. I don't know ultimately who's right and who's wrong. I know I'm wrong about some things, but I know in that story, I'd a lot rather be my daughter Lee than that angry man who was intentionally offensive. So which one do you think Jesus would approve? Which action do you think Jesus would approve? You don't have to agree with everything that somebody else believes. Give them the same grace that you want for yourself. Yeah, getting close to preaching now. Getting back to my full life. I just never could be fully happy as a full-time history professor. I was always called back to the church. And that's what I like to do. But I do like to do research too.
You know, there are a lot of ex-history professors and ex-lawyers who went into the ministry.
Oh, yeah.
Yeah, there you go.
I think the year I graduated from here, which was before I went on to Lexington, or right after I did in Lexington. Anyway, the year I graduated here, I think there were 3 attorneys that graduated there. So, yeah, a lot of.
You let them in. You let them in.
Huh?
You let them in.
You got 3 years then to really do some transformational change. Anyway, I've said all I can say, but I'm perfectly happy to answer any more questions. I don't want to keep you from class.
Thank you so much.
Thank you.
Thank you so much,
Thank you,
Reverend
thank
Buck.
you.
That was great. That was really awesome. So I definitely want to encourage you all to continue to keep September 16th on your calendar, because every year we're going to have Constitution Day either on the 16th or around the 16th. But we definitely want to thank Reverend Buck for coming out all the way from Collierville, which is 12 hours away. We do appreciate it. For those of you all that are joining us online, we definitely appreciate you all joining. And for the replay, make sure that you put comments in the comment section. Also, we have a QR code. Please scan the QR code. This will help us to know what you all, what topics you all would like to talk about and discuss in regards to Constitution Day, and just give us some feedback on how we did today. So for everyone who's here, please enjoy the food and also take food with you. And for those of you all that are online, we will see you on another day. Take care.